Welcome everybody this evening. So I'm Eloise Scotford, many of you know me. I'm the Dean of the faculty. Welcome to Professor Carsten Gerner Beuerle's Inaugural Lecture this evening. The Inaugural Lecture at UCL is a rite of passage and one we take particularly seriously. It's an opportunity for a new professor to inform a wider audience, and then we have an audience in the room and we have an audience online, about their field of expertise and their research program. It's also a moment to recognise and to celebrate a very significant achievement, that of promotion to Professor of Law. Now, I have going to get to say a few words, and then I introduce the chair, who will introduce Carsten. So we're going to go through a bit of an elaborate ritual this evening. So from me, a few introductory words. Carsten is a truly excellent colleague in this faculty, but he's also something of an enigma. Carsten, I thought that would get a Carsten raised eyebrow. Carsten is nominally a professor of commercial law, and we are going to celebrate that important promotion this evening. But I'm not sure that title quite captures Carsten or does him justice. He has travelled far and wide to get to that title, both geographically and intellectually. He started his higher education journey in Germany, a country with which this faculty has long held close ties. And then he made his way through the demanding German state exams in law, with a US LLM in between. Since then, he has studied and held posts in some of the most prestigious universities in Germany, the US, and the UK, and not just in law schools. He's studied in multiple languages, in multiple disciplines. He has degrees in economics, including an MSc, and he's threatening, you might not all know this, to do a PhD in economics. I'm not quite sure when you're going to find the time to do that.
Me neither.
And then there is his versatility across legal subfields. I have now, in this role, figured out that there are really important differences between corporate law and financial law. But Carsten does both. He researches and teaches both, as well as private international law, EU law, legal history, law and economics, comparative law, a dash of competition law, more recently law and technology, all whilst deploying robust empirical legal methods when the research question demands it. We were in this room actually at one of the brilliant Quain lectures last week when we were listening to, really, it was absolutely brilliant, but a discussion about the foundations of firmly held beliefs from a philosophical perspective. Carsten and I were chatting about afterwards, saying, wasn't that fabulous? It was really interesting. He says, of course, here I'm paraphrasing, the empiricist in me would just go and find out if those things were actually true. Carsten's enigmatic intellectualism arises partly from his unique, curious, transnational, bicultural, and deeply clever mind, but also from the fact that he's just really nice. He doesn't lord all this deep thought over the rest of us. He's a generous academic colleague, he's patient with others, he maintains resolutely high academic standards, but he's always looking to engage with, support, and develop the work of others, whether in his own field or across the faculty. And this makes him an incredibly effective and much respected Vice Dean for Research. He turns his hand to research policy, strategy, leadership, and support with ease, with an organised and open mind, and with kindness. He is really an absolute pleasure to work with. I personally value his counsel, his input, his leadership, his entrepreneurial spirit on the faculty's Dean's team enormously. You really do, Carsten, embody the faculty's ethos of excellence with humanity. You do it without fanfare, you do it with great skill, with a huge amount of hard work for the greater good. And here the enigma continues with humour. Carsten has a disarming sense of humour, which I think is a highly valued quality in academia and particularly academic leadership. Don't just take my word for it. I reached out to the Vice Provost for Research, Innovation and Global Engagement at UCL, which is UCL's big cheese for research. And he passed on this reflection about his favourite UCL Vice Dean Research. Carsten is/was, because he's already anticipating your departure from this role, which we haven't quite come to terms with, but anyway, is/was a stellar vice dean and generally all-round star contributor to the life of UCL. He's a great example of an individual who sees the bigger contribution his discipline can make to the life of the academic community, and he always engages in a collegiate fashion, and here's the important bit, with an appropriately entertaining sense of humour. So, we'll get back to the intellectual stuff now, but without generous, effective, collectively ambitious, yet individually modest colleagues like Carsten, this institution would not be as excellent, as healthy, or as esteemed as it is. So we, the faculty, do owe you, Carsten, a huge thank you, as well as our sincere respect. So I now have the pleasure to introduce this evening's chair, Professor Iain McNeel. Iain McNeel is Alexander Stone Chair of Commercial Law at the University of Glasgow, where he has held that post since 2005. Iain's early career was as an investment analyst in the City of London, covering the insurance sector. And I only mention that just to highlight this breed of financial/commercial lawyers who could go out and earn lots of money in the city, but donate their intellectual souls to academia is always notable. Iain's early career, that's the early career. Iain has served as head of school and is now head of the Corporate and Financial Law Research Group at Glasgow. His primary interest and expertise lies in corporate governance, financial regulation, and investment. He's published widely, and in particular has explored the interaction between hard and soft law in that sphere, as well as the influence of international standards. His recent publications focus on sustainable finance and stakeholder interests in corporate governance. Iain holds many other roles of high esteem. He's honorary professor at the National Law University in Delhi. He's a member of the advisory board for the Centre for Business Research at the University of Cambridge, a trustee of the British Institute of International and Comparative Law, and a chair of the International Securities Regulation Committee of the ILA. He also recently served as deputy chair of the 2021 UK REF panel for law. And on that note, I say thank you. So I will now hand over to Iain.
I have to say, this is my first experience of the UCL inaugural format. I didn't really expect equivalence with the speaker, but I'm very happy to be in that position. Let me just start with a little personal insight. There is a little bit of Carsten's CV which Eloise didn't get onto, and that is that he spent a little bit of time with me up in Glasgow in the early part of his career before he moved to LSE, and so I've known him. This is going back 15 years or so. So I've known Carsten a long time, and I was greatly disappointed when he told me he's going to go to LSE, and I thought, we're going to be left in the lurch here. Not so. He left, but he came back to Glasgow to teach courses, having moved to LSE, and this is the time before Zoom when you could do these things remotely. It's required a fair bit of travel and additional effort to do that. So at that early stage, I began to see an individual who was very reliable, collegiate, willing to fulfill commitments that had been made. And I have to say, I've never seen any real change from that pattern in Carsten over many years. He's been, in the things that I've worked with him, he's been a very reliable colleague. Now, some of you will know the character and scope of his academic contribution, and Eloise referred to it a little bit. So it's across the corporate and financial domain, capital markets law, corporate law, especially disclosure regimes, directors' duties, takeovers, important pieces of work there that feed into the policy environment as well, especially at the European level. I think for me, though, there are two distinctive characteristics that stand out in Carsten's research profile. One is the integration of some thematic approaches, you could say, into it. And I think the first one that I would note would be the strong comparative element that is fed into his work, focused on things like diffusion and transplantation, and dealing with these in the context of corporate and financial law. Another element has been the strong input in terms of EU law and the way that EU law has influenced corporate and financial law and the way that this is fed into the UK. And also, and importantly, the private international law dimension. This is, I would say, an unusual focus within the corporate and financial law sphere, but Carsten has a very strong presence there in terms of dealing with those issues. And of course, one couldn't ignore the historical rigor. Some of the work done, for example, on disclosure I've really enjoyed the historical analysis and very very substantial research that he's done in that area. I think the second aspect that strikes me in terms of his record, and this is a little bit unusual in law as a discipline, is the strong element of collaboration in his research outputs. I think if one were to look at his research record, most of the outputs are multi-authored within and beyond law, because coming back to the thematic aspect, one of his strong suits is capability in applied economics, which is quite unusual in law, and with that some considerable statistical expertise as well, and I've benefited from some of that in terms of my own work. So I think what we see in terms of a scholar is someone who is probably more multifaceted than might appear from the high-level description of the focus on corporate and financial law. This is someone who really has a very, you could say, a broad field of application, and really, I would say a very rigorous and I think also interesting approach to the way that he does things. And I think to some extent as well, I've always had the impression that there's been this kind of, you could say, relaxed approach whereby I've never felt that the outputs have been rushed. There's been a sense that things take the time that they do, and that that's kind of indicative of an independence of thinking about, here's what I want to do, and if it takes me a long time, well, so be it. Probably you would dispute that, Carsten, in terms of the challenges that you've faced. But I think to someone watching what you've done, that certainly is an impression. So I'm really looking forward to this piece on how to quantify legal rules. I mentioned to you earlier in our chat that I think this has some potential mapping as well onto AI and the potential uses of AI, although I think in terms of your talk this evening, you're probably going to focus more on leximetrics. So let me pass over to you, and looking forward to what you've got to say.
Thanks very much, Iain, and thanks very much, Eloise, for these very kind and undeservedly generous introductions. Thanks also, Iain, for agreeing to chair this lecture. I really appreciate it. As Iain said, as you said, we've known each other since the early days of my academic career in the UK, and Iain has always been there with counsel and unfailing support at every stage of my career, so I really appreciate that, Iain, and I thus think it's absolutely fitting that you should chair this lecture. It's not only fitting, it also means a lot to me, so thank you for that. I would also like to extend a thank you to my wife, who can't be here because we didn't quite figure out childcare in time, and she's at home now. She's watching online, I believe, and she's at home and looking after our kids. We thought about bringing them along, and I asked my eldest son, he's 6, I asked him yesterday if he wanted to come to the lecture. he asked me, so what's the lecture about? And I said, it's about law. Whereupon he said, boring. Who can blame him? So he decided not to come. It's actually not only about law, this lecture, it's also about numbers. So what is 42? And I'm sure many of you know. What is it?
Meaning of the universe?
It is indeed. It is the answer to the ultimate question of life, the universe, and everything from the Hitchhiker's Guide. I'm sure many of you know that. I thought it would be fitting to start with this reference because my talk is going to be about numbers, about the expression of certain concepts that are arguably difficult, or indeed some would say impossible to express by numbers. But we nonetheless, or some of us, nonetheless do it. And that is the content of legal rules, or the content of sets of legal rules that are intended to order complex social and economic phenomena. Now, I feel a bit bad that I start with this reference to the Hitchhiker's Guide to the Galaxy, because it's not my idea. I thought it's a neat way to start a talk about this topic, but I actually stole it from Matthias Siems, who started an article about a similar topic in 2005 with this reference to the number 42. So I need to give credit where credit is due. In this article, he explored whether it's meaningful to compare legal systems by means of expressing legal differences by numbers. He called this approach to comparative law numerical comparative law. He concluded that there is some value in it, but he had some methodological concerns. And he observed, and I quote, he observed that there's almost no general methodological discussion about the advantages and disadvantages of using statistical techniques and numbers in order to compare legal systems. That was in 2005, as I said. And I would argue that the situation hasn't really changed much since then. There has been some discussion about the methodology underpinning what he calls numerical comparative law. He has written not only this one article from 2005 about this, but he has written quite extensively about this topic. There are some others who have made important contributions. These include Simon Deacon from Cambridge, Holger Sparmann from Harvard. There are a couple of German law and economics scholars, Jörg Gutmann and Stefan Voigt, especially from Hamburg, the University of Hamburg, who have written extensively on that. But there hasn't really been a wide discussion about the problems of developing a methodological framework underpinning numerical comparative law. And certainly I think it's fair to say that there is no agreement on what such a methodology should look like. So I hope to explore this in my talk. I should stress, though, that, and I want to keep expectations suitably low here, I should stress that I'm not going to provide a full-fledged methodology here. I can't hope to develop a full-fledged methodology underpinning numerical comparative law in, how much time do I have? 50 minutes or so, which is remaining. The goal is more modest. So what I will try to do here is I will offer some thoughts on what I think are the important questions in this debate, and especially questions that I think have remained underexplored. I will offer make some very tentative suggestions for how we might go about answering these questions or analyzing these issues. and I will map out avenues for future research. And this future research will then, hopefully, eventually lead to a more mature methodology to compare legal systems. So that's the plan. I have one more number for you, 4.00. What is that? That's a bit more difficult to answer, I think, and it is actually from this paper, from a paper from 1998 called Law and Finance, published by 4 US American-based financial economists, Rafael Laporta, Florencio Lopez de Silanes, André Schleif, and Robert Vishny. It's a hugely influential paper. I think it's fair to say that with the publication of this paper, the story of numerical comparative law started properly. The number 4.00 is over there. It's the average level of investor protection, minority investor protection, in common law jurisdictions. In English, origin average countries. So what they do is they form an index, a legal index, that is composed of a number of elements there that you see at the top of the table. They ask for each element whether the respective rule is present in a particular legal system or not. If it is present, the relevant country gets the score of 1. If it's absent, the country gets the score of 0. And then this is all added up and results in here for common law jurisdictions an average score of 4. The United Kingdom and the United States, they fare quite well. They get an average score of 5. So this way of analyzing legal systems, of comparing legal systems, has become hugely influential, both in academic circles and also in policymaking circles. I'll say a little bit more about that in a moment. And the title of the paper has become eponymous for a whole field of research, law and finance. These guys, Laporta et al., they've written a number of additional papers that follow up on the claims they make in this initial publication. And many other scholars, financial economists, and also legal scholars have used this index and some other indices that they have developed in their own studies. So this line of research has become hugely influential. It has also attracted a lot of criticism, especially from legal scholars, and here especially from legal scholars based in continental Europe, possibly because they felt somewhat offended that their own jurisdictions in continental Europe didn't fare as well as the United Kingdom and the United States. So if you look at France, for example, here, France got a score of 3 in this index. The index is called the Anti-Director Rights Index. And if you keep looking, Belgium got a score of 0. Very impressive. By the way, I use this table in my course, in my LLM course on comparative corporate governance. In one of the first lectures, I always show this table. And I typically have a nice discussion with my students, especially those students coming from such jurisdictions, unsurprisingly, strongly disagree with this assessment of their corporate law systems. And it's arguably quite easy to disagree with this line of research and these findings, because the main claim that Laporta and al. Make is almost outrageously simplistic and reductionist. So what they say is that these legal differences between jurisdictions that are encapsulated by the Anti-Director Rights Index and other indices, these legal differences, they explain a variety of economic and other social outcomes, ranging from financial development, so the size of stock markets, to the question, who owns the corporate economy? Is corporate ownership concentrated in the hands of families or other block holders, or is it widely dispersed? And their claim applies to other outcomes, to, for example, ownership, government ownership of the media, the unemployment rate, or the independence of the judiciary. All of these outcomes, they say, can be explained with legal differences that map onto legal families. So ultimately, they say, what matters in predicting and understanding these differences in economic and social outcomes is the association of a jurisdiction with one of four main legal families: the common law, French, German, or Scandinavian law. And depending on which legal origin applies or which legal family a jurisdiction falls into, outcomes that are very different from the actual legal rules. So certain social characteristics, economic characteristics can be explained. So at first sight, this is a heroic claim, and a claim that can fairly easily be criticized by simply looking at the classification in legal families. I will talk a little bit more about other methodological challenges in a moment. But in spite of this criticism, the findings have been picked up by policymakers around the world, notably to give one important example, by the World Bank, the World Bank compiles so-called doing business reports where they assess and rank the business environment of economies around the world. And this ranking and assessment is based on the methodology that Laporta et al. Developed, that they proposed in this line of research, such as the Law and Finance article. So this is another slide I like to show my students because it drives home the message that legal origins and legal differences as represented by the Anti-Director Rights Index and other indices are important, have real-world consequences. So this slide, it shows on the x-axis a score for, or an index for minority investor protection, similar to the Laporta et al. Anti-Director Rights Index, but somewhat extended. So that's the World Bank ranking or World Bank index. And on the y-axis, market capitalization of listed companies as a percentage of GDP. And so the blue dots are country-level observations. The line is a fitted line that shows the best linear approximation of the association between the two variables. So there is a positive association between minority investor protection and certain financial outcomes, here, size of stock markets. If this positive association has a causal interpretation, and according to the World Bank it does, then there's a clear normative message in this figure, and that is legal reform should be informed by legal solutions proposed by those jurisdictions that get a high score in, for example, the Anti-Director Rights Index. And that means, in particular, as we've seen on the previous slide, the United Kingdom and the United States. So these are the real-world implications of this line of research. It's therefore important, I think, that we can have confidence in the robustness of the methodology that underpins this research. Now I want to take a step back and want to talk a little bit about methodological approaches to empirically analyzing the law. And I'm simplifying greatly, but I think there are two broad options, or two broad designs, methodological designs. One focuses on a policy change that affects a subset of a population that is otherwise comparable, and the empirical technique that is used, there's typically differences in differences. And the other is where we don't maybe find a particular policy change, to look at existing legal differences across countries and use these legal differences, score the legal difference somehow, quantify them somehow, use them as an explanatory variable, and then show if there's an association and possibly also causality between that explanatory variable and an outcome variable. So these are, very broadly speaking, the two approaches that you find in the empirical legal scholarship. The first one, differences in differences, lends itself relatively easily to a causal interpretation, provided that a number of conditions are satisfied, in particular that we have two subpopulations where we can postulate, or where we have confidence that they develop in parallel along the relevant dimensions we are interested in. And then there is one exogenous shock, so a legal change that changes the trend in one of the subgroups, the treated group, whereas the legal change, the treatment, doesn't affect the control group. So this methodological design has been used recently, for example, in the United States in order to analyze the effects of a change to a rule in the Model Business Corporation Act. So that's a model act in the United States that suggests, it's, as the name indicates, it's not binding, it suggests to state legislatures how to reform their corporate law. So this change in the Model Business Corporation Act required demand to be made on a board of directors where minority shareholders wanted to bring a derivative action. The hypothesis here is that this legal change introduces an additional procedural hurdle to bringing a derivative action. So we can hypothesize that the effect of this is that the frequency of bringing a minority shareholder lawsuit decreases. The change in the Model Business Corporation Act has been implemented by some states in the United States and not implemented by others. So we have a set of states, which we can call the treated group, where the change came into the statute books, and we have a set of states, the control group, which were not affected by the treatment, by the legal change. And then it's relatively easy to understand whether the legal change actually had an effect on outcomes, provided we can make the assumption that trends in the two groups moved in parallel and would have continued to move in parallel had it not been for the treatment. So there's a causal interpretation that is justified if these assumptions can be made. There are certain methodological challenges and nonetheless, and this literature on universal demand laws that has also led to some controversy, but there's a relatively straightforward way to make causal inferences. For purpose of my talk, there's another advantage with this design, and that is that the law can be quantified very easily. It's trivial to quantify the law for purposes of including it into this model. There has been a legal change or there has been no change. So the question is simply a binary question. This is more difficult with the second methodological design, and that's what I want to focus on now for the rest of this talk. It will not always be possible to use differences in differences, especially if there is not one clear legal change that could be identified and isolated easily. and also for cross-country comparison rather than comparison within the federal system across states. It is often not possible to make the parallel trends assumption because countries vary across so many dimensions that it's quite unlikely that that assumption will be satisfied. So if we can't use this first methodological design, differences and differences, then the alternative is that we try to quantify. I'm going to say more about that in a moment. We try to quantify existing legal differences. We use these existing legal differences as an explanatory variable. So the model will often look like this. We have an economic outcome, say firm performance or so, and we hypothesize that certain legal differences across countries or across firms have an effect on the outcome. So we put these legal differences as an explanatory variable on the right-hand side of the equation and include a number of controls, firm-level controls, country-level controls, etc. The critical question is, how do we represent the legal differences as this variable law? The typical approach is to form legal indices, such as the Anti-Director Rights Index that I've shown you before, where a number of questions are asked. So a number of legal rules are analyzed, and then often the individual legal rules are simply added up. So where an individual legal rule is present, the relevant country gets a particular score, and all the scores are added up in order to form the total score of the legal index. So that is the typical approach. And legal indices are often formed in a very simple way by aggregating, as I have described it, without putting much thought to the question whether all the components, all the elements of the index should be weighted equally, for example. Whether some legal rules are more important than others. So normally it's simply aggregation or averaging out. And typically, though not always, legal questions are answered also in a binary way. So either you have a rule, this is an example now again from the Anti-Director Rights Index, either you have a rule that provides that all shares shall carry one vote per share, or you don't have such a requirement. Intermediate solutions, which you in practice, of course, often find in the law, are not accounted for. Say you have something like loyalty shares that develop multiple voting rights after a number of years. So this is the normal way, the classical way of constructing a legal index. And you have many examples from the literature where index construction follows this pattern. I mentioned the first example here, the Anti-Director Rights Index that has been revised, but it's still used in research. Another index I'm going to talk about in some detail in a moment is so-called anti-self-dealing index, which tries to capture the regulation of related party transactions, developed by the same people, largely the same people that published the Law and Finance paper. Just a few additional examples of influential indices. A governance index, I will give you, give you a snapshot of what this index contains also in a moment. And then one index I will mention a number of additional times is a so-called Management Insulation Index, which has been developed by some former colleagues of mine at the LSE, and one of them is here, Tom Kirchmeier. So he can correct me if I say anything that is wrong about this index. The one example from this list that does not follow the pattern of index construction that I just described is this last index. And I'll have a little bit more to say about that in a moment. So there are a variety of methodological problems that arise when we follow this second design approach. We put the law as an explanatory variable onto the right-hand side of a regression equation. The ones that you see here have been widely discussed in the literature. I already mentioned that it's highly questionable whether it is meaningful to classify legal systems neatly as falling within one of four legal families. Often, legal systems are influenced heavily by different legal traditions. And some would argue this classification, it's quite old, right? That we associate a jurisdiction with a particular legal family. This classification doesn't really make much sense anymore today. There was also some discussion about, as regards the foundational law and finance research, about the relevance of the legal variables that were included in the indices, and whether the legal variables were coded consistently across countries. There were arguably some misunderstandings in how the legal rules applied and how they should be coded. And there has been some discussion about whether the law as an explanatory variable is actually exogenous, which is a requirement in order to be able to make causal inferences or not. I don't want to talk about these challenges. They're all valid challenges, and they have received a lot of attention, but I don't want to tread I don't want to follow this well-trodden path. I want to instead focus on ways to construct a legal index, which I think is a problem that is, on the one hand, crucial to this whole endeavor of translating law into numbers, quantifying legal rules, but on the other hand has received comparatively little attention in the literature. And I think there are four challenges that we should think about when we construct legal indices or try to understand whether an index construction is sensible. I already mentioned the weighting of index components. Then there are three additional challenges which I would bracket under the heading of interdependence, the problem of interdependence. And that shall be the focus really of what follows now. I would distinguish between three problems of interdependence between legal rules, which I call functional substitutability, complementarity, and contingency. Now, legal rules, I think you will probably all agree, and in general, lawyers will agree, legal rules don't operate in isolation. We can only really understand the meaning of a legal rule if we look at it in context. And I would posit that there are these three ways how legal rules can interact with the context, can interrelate with other legal rules. And I'll talk about each of these in turn in a bit more detail. Just very briefly on the weighting of index components, in order to underline the point I've already made, that typically, with the exception of Thom's index, typically indices are constructed in a very simple way. Take this so-called G index, governance index, also a hugely influential index in the law and finance literature. The authors look at a pretty long list of legal rules, 28 in total. And the analysis here is at the firm level. For each rule, they ask whether it applies to a particular firm or not. And from the article, they are quite open in that this is a pretty simplistic way of constructing the index. They say, the authors say, this index construction is straightforward. For every firm, we add 1 point for every provision that restricts shareholder rights and increases managerial power. This power distinction is straightforward. While this simple index does not accurately reflect the relative impacts of different provisions, it has the advantage of being transparent and easily reproducible. So, they're quite open about the potential shortcomings of this. That's the first challenge. And what follows will, as I make some suggestions about alternative ways of index construction, this will have some bearing also on this problem of weighting index components. The second issue I called functional substitutability. Now, it's well known in comparative law that legal systems often use different legal solutions in order to address the same social problem. Legal solutions that maybe differ doctrinally, or that at least follow different terminology. If a comparatist looks at a particular legal rule, at a particular mechanism, formulated in a particular way, and doesn't find it, finds it in one jurisdiction, but doesn't find it in another jurisdiction, then the comparatist will typically ask, well, what is the reason why this rule is not there in jurisdiction B? Is there a different mechanism that is functionally comparable, that operates as a functional substitute? And if there is, then the effectiveness of regulating the relevant social conflict might be very comparable across legal systems. But index construction, often, not always, but in many cases, legal indices do not follow this approach. They look at one formulation of a legal mechanism and look at a clear equivalent in another jurisdiction. And when they don't find it, then the index value or the score received by that jurisdiction is a 0. So an example for functional substitutability from the UK would be, and my examples, I feel I should apologize, my examples all come from corporate law. So I'm maybe not that enigmatic. I'm a corporate lawyer, after all. So if you think about the enforcement of breaches of directors' duties, and this is directors' duties and breaches of directors' duties is something I will expand on also later. So if you think about the enforcement of directors' duties, this enforcement mechanisms can be private, or they can be public or semi-public. Private enforcement mechanism would be simply a derivative action brought by a shareholder or an action brought by the company. Public enforcement mechanism or semi-public enforcement mechanism in the United Kingdom might be something like the disqualification of directors, which needs to be ordered by the court and is brought on application by, for example, a liquidator. The effect of these very different legal mechanisms is, to some extent at least, comparable. They both sanction a breach, or can sanction, a breach of directors' duties. So that's a straightforward example for substitutability. If substitutability, functional substitutability, is not taken into account in a regression equation, in an empirical model, then that would result in omitted variable bias. So we only look, say, at the derivative action mechanism. We do not look at substitutes that qualify as a public enforcement mechanism. Would result in omitted variable bias. In that case, the estimates will be not reliable. So the estimator will be inconsistent and causal inferences will not be justified. Okay, that's functional substitutability. The second problem, complementarity. Again, the idea here is straightforward, that some legal rules, or many legal rules, will not operate effectively without a second rule. We can again use enforcement as a simple example. You have, say, a behavioral standard, so the duty of care imposed on directors, for example, and you have enforcement mechanisms. You might argue, some people or many people would argue, that the behavioral standards will not really influence behavior if it cannot be enforced. Now, there's maybe a bit of a philosophical debate to be had about that, to what extent, even without enforcement, certain behavioral expectations will be effective. But it's a standard assumption, at least in law and finance scholarship, that without enforcement can't be expected that a legal rule will actually influence behavior. So in this case, both rules are complements. What not accounting for complementarity means in order to produce reliable predictions in a regression model is a bit more difficult to assess. And I have a couple of slightly more technical slides to explore this question in a moment. But before I come to that, the third example or case of interdependence is what I would call contingency, that the effect of one rule is contingent on certain prior decisions or states of the world that are in turn affected, constrained, enabled by another legal rule. The example that I will give you on the next slide regards the regulation of self-dealing, regulation of related party transactions. Again, if this interdependence is not accounted for in a model, it will result in a measurement error. So, the example. This is, quote, from the so-called anti-self-dealing index, which I already referred to from Jankov and others. This is one variable definition. The index is composed of a number of elements. I want to focus on two of these elements which are particularly relevant here for my purposes. The first one is what the authors call the ease of holding an interested director liable. They define this variable, or they state that this variable equals 0 when the interested director is either not liable for a related party transaction at all, or liable only in cases of bad faith, intent, or gross negligence, equals 1/2. So there we have an incremental step in how the variable is coded. 0, 0.5, when the interested director is liable, so 0.5 if the interested director is liable if he either influenced the approval of the related party transaction or was negligent, and equals 1 if the interested director is liable if the transaction is unfair, oppressive, or prejudicial. Okay? So these are degrees of severity. The legal requirements become more demanding if they impose liability whenever a related party transaction is unfair. Now, you might want to take some issue with this, with the equivalence between unfair and oppressive. In corporate law, oppression means something very different from entire fairness. But and I agree that this is a problematic formulation, but I don't want to focus on that. I want to focus on another point. So, if we use US law, Delaware law, to be more precise, as a reference point, Delaware law received the value 1 here, the score 1 for this variable. So let's keep that in mind. The second element, the second important element for my purpose of the anti-self-dealing index is approval by disinterested shareholders, defined as follows. It equals 1 if the transaction must be approved by disinterested shareholders and 0 otherwise. Here, Delaware law received the score of 0. Let's have a look at Delaware law, okay? At the relevant provision. That is section 144 of the Delaware General Corporation Law. This section says that a related party transaction, a transaction between a corporation and one or more of its directors, shall not be void and shall not lead to liability of the director if, 1, material facts are known to the directors, and then a majority of the disinterested directors approve the transaction. 2, material facts are known, and the disinterested, you need to read this as disinterested stockholders, approve the transaction. Or 3, the transaction will stand if it's fair as to the corporation as of the time it is authorized. Now, how does the definition of the two legal variables from the previous slide map onto this? I think quite badly, because first, it is true that there is no requirement of shareholder approval. Shareholders can approve. They don't have to approve. So I guess I would agree with the score of 0 for the second element that I showed you on the previous slide. But what about the first one? Directors are liable if the transaction is not fair to the corporation. Now, this is not how US law, how Delaware law works, right? We only come to the entire fairness test if there is neither disinterested director approval or disinterested shareholder approval. That's what I mean with contingency. That the trigger of the entire fairness test depends on whether we had disinterested director or disinterested shareholder approval or not. By the way, there's no mention of disinterested director approval in the variable definition from before, which is, for practical purposes, the most common way how related party transactions are approved. So we have difficulties applying the definition from before to this particular regulation of related party transactions. We would have similar differences in other jurisdictions if we try to apply that, because the definition doesn't take into account what I call contingency. So what does that mean for purposes of estimating the effect of a legal variable on a particular outcome? It's getting a bit technical now, a bit, so apologies for that. Tom will know that better than me, so if I explain that incorrectly, again, please just correct me. Estimates are biased and inconsistent, meaning that causal inference is not justified, where we have measurement error, and this measurement error is correlated with the observed imprecise measure, but not the unobserved precise variable, or it's correlated with both the observed measure and the unobserved variable. So that is well established, and you can see a derivation of why that is so. You can find that in any econometrics book. I wanted to spare you the derivation of why estimates become inconsistent if there is measurement error, and the measurement error is correlated with the observed imprecise measure. What I want to explore a little bit is whether this is the case in my two examples of interdependence that I discussed. So let's consider a simple model where, okay, the economist would say a simple model, where the lawyer might beg to differ, where we have a particular outcome, that is y. So say firm performance or so. And that is a function, we hypothesize, of beta 0 is just the intercept in the model, of a first legal variable, which I call xst. The beta is the coefficient on the variable. So it will, when we estimate the model, it will show what is the influence of xst on y. So xst stands for a behavioral standard. And we put a second legal variable into that model, which I call xenf for enforcement, which represents an enforcement mechanism and an error term. Okay? So I would now postulate, again, we can debate that, but for the sake of argument, let me postulate that a behavioral standard does not influence actual behavior if it cannot be enforced. Enforcement is simply impossible. And on the other hand, similarly, an enforcement mechanism is irrelevant if there's no meaningful behavioral standard to be enforced. Okay? So if we want to express this in a more formal way, then we can say the following. Enforcement, the variable that measures enforcement, takes the value 0 if the behavioral standard is meaningless. So I call the behavioral standard, there's a tilde here on the x, because this now refers just to the behavioral standard. How the behavioral standard, say, the duty of care is formulated. It doesn't take into account that there's interdependence. Okay? The actual variable, in order to be measured correctly, I argue should take into account interdependence. But the enforcement measure, as we just said, is irrelevant. It doesn't influence behavior if the standard as such, disregarding any interdependence, if the standard as such is not meaningful, then there's nothing to be enforced. Okay? And the enforcement measure takes a value that is not necessarily 0. It might be 0 because enforcement is impossible, but it might be higher than 0 if the behavioral standard is meaningful. Okay? And we do the same for the behavioral standard. It's analogous. It's 0 if enforcement is impossible. It might be non-zero if enforcement is possible. It might still be 0 because the behavioral standard might be formulated in a way that it is meaningless. So, for example, a corporate law system allows the company to exclude liability for monetary damages in their certificate of incorporation. Okay? So, I hope that's clear. Now, as I said, causal inferences are not justified if the measurement error is correlated with the observed imprecise measure. Now, let me call the observed imprecise measure x prime in order to distinguish it from the actual variable, from the true variable x. Okay? So, we said, and I just look at xst, so the behavioral standard, but there's, again, an analogous line of reasoning for the enforcement side. So xst, we said the behavioral standard xst equals 0 if either enforcement is impossible or enforcement is possible but the behavioral standard is meaningless, or both. Now, let's assume that x prime st measures x st correctly but does not account for interdependence. So it simply looks at what I call x tilde. So that stands for the formulation of the behavioral standard, say the duty of care, without any taking into account any interdependence. Let's say x prime is measured as 0. It just looks, as I said, X prime doesn't look at interdependence. So it just looks at the behavioral standard itself. So the behavioral standard must be 0. That's one of the two cases. That's one of the two cases where X, ST, the true value, the true variable, equals 0. Yeah? That's what we defined up here. X, ST equals 0 if the behavioral standard is meaningless. So that's the first alternative. The second alternative is that what we measure, X prime, takes a different value from 0. In that case, X, ST may or may not equal 0. So the true value may or may not be 0. This depends on enforcement mechanisms, as I said, because there's interdependence. So there will be no measurement error here, right? If X prime is 0, the true value is 0. We just established that. If there is measurement error, it will only apply in this case. That is correlation. Yeah? If the measurement error is greater than 0, we know X prime cannot be 0. So the measurement error is correlated, we established. The measurement error is correlated with the observed imprecise measure. I hope that's reasonably clear. That means the estimates are biased. That means causal inference is not justified. Now, I think that that is an important point because most indices, as I said, do not take account of interdependence. So there will be, in many cases, measurement error. And this will, in many cases, be a measurement error of the type that renders the estimates biased. So we need to be careful. And there are other reasons why we need to be careful with empirical findings from the law and finance literature. But this relates to index construction. So we need to be careful, depending on how the index, the legal index, is constructed. We need to be careful with whether we can have confidence in the findings, whether we can make a causal inference. So what can we do about that? How can we improve the situation? I would suggest, in order to account for interdependence, we can take 3 steps. What follows is, to some extent at least, inspired by Tom's index, the Management Installation Index. So first we want to identify, of course, all relevant legal variables that have a bearing, or at least potentially a bearing, on the social phenomenon that we are interested in, that we are analyzing. And then I would argue we should group these legal rules into these legal mechanisms into what I call here building blocks. These building blocks should be defined in a way that rules that exhibit strong interdependence should be captured under one building block, as part of one building block, whereas building blocks should be formed so that there is no strong interdependence between the building blocks. There is within, but not between. And then for each building block, we will try to map the interdependencies. This could look like follows. So this is what the Management Installation Index, which I mentioned before, does. It's, if you look at that paper, it maps relationships between legal rules. And that's what I want to now also do. So the starting point is to stick with this example that I have been using. The starting point is that the risk of monetary liability sets incentives. So only the risk of monetary liability sets incentives and influences behavior. what is the risk of monetary liability in the corporate context that the director is found liable dependent on? It is dependent on, first, the definition of the relevant conduct, what is expected of the director. So the content of a duty, of a director's duty. Secondly, it is dependent on the question whether firms can limit or exclude liability, whether they can exclude certain types of behavior ex ante, for example, in the Articles of Association, from the type of behavior that can give rise to liability. Thirdly, the risk of liability depends on whether the director will be indemnified or whether the director is covered by insurance, D&O insurance. Fourthly, you might want to ask the question whether certain conduct can be excluded ex post from the set of behavior. So after the fact, from the set of behavior that gives rise to liability, for example, by procuring a resolution by the general meeting that exculpates the director. And fifthly, we talked already about enforcement. So all of these elements, I would argue, have a bearing on the ultimate risk exposure. How are we doing time-wise, by the way, Iain?
So we probably want to conclude.
Okay, I have a few more slides. So this gives an overview of the relevant legal provisions in Delaware that address these questions. The definition of the duty of care at the top. I included also the duty of loyalty. So when we talk about duties, we usually will have a look at these two. The possibility of ex ante limitation of liability. That is allowed under Delaware law in the certificate of incorporation, except for acts done in bad faith. Companies can indemnify directors, provided the director is not held liable and has acted in good faith. And companies are allowed to insure directors, take out D&O insurance, including in cases where indemnification would not be permissible. Ex post waiver is also possible, of course. Shareholder ratification is possible, provided the relevant act was not fraudulent, but ratification does not extinguish liability. It reinstates the starting point, the business judgment rule. And this gives a brief summary of enforcement under Delaware law. Any shareholder can bring a derivative action, and I already mentioned shareholders need to make a demand on the board. So I think it's quite easily to see that these three conditions are interrelated. They are interdependent. It's more difficult, I would think, to define interdependence when we talk, for example, about the ex post possibility to exclude liability. But interdependence here is quite clear, I would think, because ex ante limitation of liability will change, for example, the relevant standard of care. And likewise, indemnification for certain types of conduct will change what effectively gives rise to liability, etc. So I've tried to map this. And you might think, now this looks a bit complicated. And I have something to say about that as well in a moment. What I did here is I asked for each standard of conduct that might give rise to liability under a legal regime. For example, starting at the very top, liability for any form of negligence. Below this, liability for gross negligence. Here, liability for bad faith conduct. I asked for each possible standard that might give rise to liability. First of all, whether that standard applies in the relevant legal system, whether it does give rise to liability, whether it can be changed contractually in the Articles of Association, for example, whether the company can indemnify the director for breaches based on that type of conduct, etc. And if the answer to these questions is, for example, the company can exclude liability, I move on to the next most demanding standard and ask the same questions. That's why it looks a bit convoluted, this picture. But that arguably captures the interdependence. And then I arrive at a particular score here. Now, I don't want to dwell on the details. I will probably include this figure in the paper that will eventually be published, but I want to make a different point. I did the same for the duty of loyalty. It looks equally complex. So I want to ask a different picture here. This is my attempt to capture interdependence. If I'm to venture a guess what is going through your minds at the moment, it might be this. Am I complicating things too much? Now, I had a discussion about this question and about this approach to mapping interdependence. I had a discussion about this with Jörg Gutmann from the University of Hamburg, who has written on index construction. And he said, yeah, I agree, measurement error might be present, but you are really exaggerating that. It might be present in some cases, it might not be particularly severe, it might not be present in other cases. What's the purpose of complicating the whole taxonomy that substantially? Because this also comes with risks to try to map interdependencies. And the most important risk here, I would think, is that we inject subjectivity. I presented my mapping exercise fairly quickly. And I didn't dwell on the details, partly because of time constraints, partly also because this certainly will open up questions about whether this is the only way to map interdependencies. And in many cases, there will be different ways of accounting for interdependencies. So as soon as we start to move away from this very simple index way or method of index construction, which I criticized initially, this very simple way of simply aggregating, counting in a binary way, 0 or 1, and aggregating. As soon as we move away from that, we inject subjectivity and also the possibility for scientists to engineer a little bit the findings or the study. Engineer the definition of the index until they find a statistically significant association. So this is the cost that I refer to. And now you could say in response to this argument, yes, but everything is connected in the law. We need to take account of these interdependencies. The law is a seamless web, as some would argue. This idea goes back to Maitland in this quote, although he talks about history as a seamless web. So we need to take account of interdependencies in order to fully understand how legal systems or legal rules, individual legal rules, operate. Now, in response to this, I would say, well, to some extent, of course, there is a web of legal rules. But to describe the law as such, as a seamless web, I think is probably not a terribly accurate description of how the law actually operates. And I have another quote from a line of articles, or this concept is developed in a line of articles by Henry Smith. Has nothing to do with corporate law. It's from property law. And in this article, he says, the law operates in a modular way. It's modularized. It looks at particular sets of rules that it bundles together. Within these bundles of rules, there is interdependence. But these bundles can be transplanted fairly easily to other contexts. So between bundles, there is little interdependence. And he uses as an example boilerplate in contracts. So he says, contract terms are often highly idiosyncratic. That means they can only be understood if you look at the contract as a whole. But then at the same time, you have boilerplate, pre-formulated passages that can easily be plucked out of a contract and can be put into another contract. And he says the law does that. It modularizes in order to decrease costs, the costs of communicating about legal relations. So the law prefabricates these modules. And I think that is, and I will conclude on that thought, I think that is the challenge that we are facing when we construct indices. That we should try to identify the modules where legal rules indeed interact closely, where they interrelate, and we can't fully understand an individual rule without looking at all of the rules in the module. That's what I called earlier building blocks. So where we have a building block, or where we identify that there is a building block where rules interact, I think we should at least try, when we construct indices, to account for these interdependencies in order to avoid measurement error as much as possible, provided we can do that in an objective and scientifically sound way. Between building blocks, or between what Henry Smith calls modules, we don't need to worry so much about interdependence, because given how the law is designed, interdependence will be less important, and there we can simply aggregate, or we can put different legal variables separately into a regression equation. I appreciate this is not a definitive answer to the challenge of how to construct indices, but I said at the outset, not really going to provide answers to many questions, certainly not to ultimate questions of life, etc. I think this is a way forward for future research, and how precisely to identify modules or building blocks, and how to map within building blocks. That is something that I think would benefit from additional research, which I might engage in after I step down as Vice Dean Research. So thank you very much for your attention.
This, I have to say, to me, seems like an idea that is well worth pursuing. I think that, there's a really good contribution that could be made here. And as I was saying earlier, I think possibly it's got applications that go beyond lexometrics in terms of thinking about what quantification of law can do in other domains, such as AI. I'm going to pass back over to you, Eloise.
I have one final formal duty to perform. Now, I know, Carsten, you might need to stand up. And come over here. So I know you've been calling yourself a professor for some time, but...
I shouldn't have,
shouldn't.
Apparently.
But the last moment of this formal bit of the proceedings is for me to, on behalf of the Faculty of Laws, to formally inaugurate you, Carsten Gerner Beuerle, as Professor of Commercial Law in the Faculty of Laws at UCL.
Thank you very much.